One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on association disclosure.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, we're going to take a look at the Property Owners Association disclosure. And before we get into that, I just want to remind you this is not specific legal advice. That's always very fact dependent. Rather, this is just a broad overview. And the Lismore and Associates agents use three different contracts in the company's geographic area. There's the RAIN contract, which is used primarily on the Virginia Peninsula, the CVR contract, which is used in the Richmond area, and the VR contract, or Virginia Realtors contract, which is used in the Williamsburg area and across the state, really. Each of the contracts handles some things a bit differently, but in the context of this segment, the Property Owners Association Disclosure Act, it's really the same because it's mandated by state law. Some of the contracts have the language all in the contract, some use an addenda, but essentially what they have to say and what is said is regulated by state law. In any event, the three contracts are really all fairly drafted for both buyers and sellers, and that allows your Lismore and Associates real estate agent, whether he or she's representing you as a buyer or representing you as a seller, to use the same form regardless. So again, the purpose of this Get Smart segment is to drill down on the Property Owners Association Act disclosures and how that works. But if you have any questions or concerns, you should ask your Lismore and Associates real estate agent. All right, so what is the Property Owners Association Act? Well, that's part of Virginia law, and it regulates homeowners associations. It uses a broader term, property owners association, but most people think of that as a homeowners association. And we all instinctively understand what that is. There's a development or a subdivision, there's an association, there are dues, they're paid in, and from those dues, the property owners association takes care of common areas and enforces certain regulations that are imposed upon the subdivision and acts as a little mini government. Well, if that is in fact the case, then under Virginia law, that triggers certain disclosure. A seller is obligated to disclose whether the property the seller is selling is subject to the act. Now, quite frankly, that's really both simple and complicated, if you can imagine that. And it takes lawyers to make things that are otherwise simple complicated. But it's easy to see in a subdivision where everyone knows and it's very clear there's an association and there are dues and there are maintenance obligations and the ability for assessments and there are common areas, whether it's a pool or a park or whatever the case may be. And so everyone instinctively understands that. But you can have some areas, some subdivisions where it's much more complicated. An owners association hasn't been formally formed, or maybe it's a voluntary association. And so in that regard, trying to figure out whether property applies, that actually can get pretty complicated. And if that's the case, or there's any doubt, a seller should talk to his or her Lismore agent, and let's see if we can figure that out before you're accepting an offer. So what does the law require in terms of disclosure? Basically, the Virginia law specifies that a seller is obligated to obtain from the association a packet of information and to provide that to the buyer. And then the issue becomes, with that disclosure, what rights does a buyer have? So let's look at the seller's obligation specifically. Again, as I mentioned, the basic idea is first, the seller's obligated to disclose whether the property is subject to the act. If it is subject to the act, then the seller is obligated to obtain the required specified packet from the association, and the association should know how to do that and to provide that information to the buyer. Noting how must that disclosure be made and to whom? Well, again, Virginia law specifies what needs to be included in the packet, and the contract is going to, and fundamentally the law says to the buyer, and the contract, regardless of which contract, it's going to designate whether that's to go to the buyer and how, whether it's by Federal Express, by its electronic means, through email, whether sending it to the selling agent is okay, who in turn needs to get it to the buyer. So the answer to the to whom and how is really, first blush is to the buyer, but realistically the contract is going to specify. And I would note for the seller, you need to follow that language exactly. If it says to the buyer by electronically or to the buyer electronically, then it's not okay to print it out and drop it off with the selling agent. That will not comply with the law. One thing that occasionally comes up is, for whatever reason, buyers may be out of town, and the parties might need more time. The basic time period for a buyer to cancel after receiving it is 3 days, but maybe you need more time. You would think that it would be easy enough to just simply agree contractually to extend that time frame, but the problem is that the law itself has language that says the parties may not vary the requirements. And that may not vary is a little scary. You would think it would just simply be okay to give the buyer another 2 to 3 days, but with that language in the statute, it's not clear to real estate lawyers whether you can do that. So the solution is to simply give the buyer another 2, 3, 5 days, whatever time period is being agreed to, the unilateral right to terminate the contract for whatever reason. I would not say it's under the Property Owners Association Act. You just simply give the buyer the right to terminate for whatever period, and that should cure that problem. Talk to your agent and make sure you understand that, and your agent can circle back with me or a different attorney for explanation. Another problem that arises quite frequently, and I identify here with rather vague correcting problems. So part of the typical packet and the statutory obligation is for the association to disclose whether the property, the house really, but it can be the property at large, is in violation of any rules and regulations, architectural guidelines, for example, of the association. So, for example, the association may do its inspection and come back and note that the house doesn't have the correct shingles or shutters, or this is something's in a state of disrepair, and call for it to be repaired. Well, that may come as a shock to the seller, and the seller says, well, I'm not fixing that. I didn't agree to fix it. Well, that's actually pretty complicated, and I always answer those questions on a case-by-case basis depending on exactly the language used, what the Homeowners Association had to say about it, and whether the parties have addressed it in any other way. From the standpoint of a buyer, a buyer can argue that being in violation of the covenants, really, that attach to the property means that there's not clear and marketable title. The seller, of course, can argue that he or she didn't agree to that, and it's not exactly marketable title problem, clear and marketable title. So it's not always abundantly clear from a broad perspective. The solution, of course, is to address in the contract early on by addenda what's going to happen. Either the seller is going to make those repairs and correct them, or the seller isn't. And if the seller needs to have a cap on the amount of potential repairs since they're unknown, then of course that can be written in as well. So basically, this law is for the benefit of a buyer. And the benefit to the buyer is that, A, the buyer finds out that it's in an association, gets the basic information about what that means, that is, how much the dues are, copies of the covenants, the declaration itself, is able to review all of that. And the buyer has a 3-day right to terminate under the law once the buyer gets that packet. And that's really an unfettered right. The buyer doesn't have to give any reason for that. There's case law on this. The buyer can just basically look at it, say, I'm not satisfied, I'm canceling, and just terminate the contract, and then the seller's obligated to refund the deposit and the contract's over. I'd note a couple of things. Screen advanced, sorry about that. First of all, a buyer does not need to wait for the packet in order to terminate. The laws are very clear that a buyer can terminate within 3 days after getting the packet, 3 days after being advised the packet is not available, or at any time prior to receiving the packet or the notice that it's not available. So in other words, a buyer need not wait, and sometimes a buyer want to terminate, and the listing agent seems to think, well, you can't do that yet because you don't have the packet. That's just wrong. I'd note also that, it's not unusual, closing maybe 30, 45, 60 days down the road, packet comes in, it's requested right away by the seller, and things can always change. So a buyer has a right to request an update. That's done at the buyer's expense this time, but the law doesn't give the buyer a right to cancel based on the update. If the buyer wants that right, that needs to be written in the contract initially. Note that the buyer's remedy for the disclosure not being made is to cancel the contract. The statute talks about that being the sole remedy available to a buyer, so it's doubtful whether a buyer could sue later. There is some theory that there can be a lawsuit against the seller for misrepresentation, but in any event, just know that a buyer's basic right, the one clear right, is the right to terminate prior to closing. I talked about a moment ago about the idea of extending the time period. If that needs to be done, then do it by a separate addendum that does not reference the act itself, just to avoid any issues with the language in the statute about may not vary. And then from a buyer standpoint, whether the seller is obligated to remedy any architectural maintenance issues, the best way to handle that is to have an addendum very early on at the beginning, with the offer that says the seller will do so. So as you can gather, this is a reasonably complicated area and provision of the contract, and it's the kind of thing that lends itself to specific answers based on a specific question. The purpose of this Get Smart segment is to really provide an introduction, talk about some of the issues that come up, and to give you some guidance. But as always, talk to your Liz Moore and Associates real estate agent, and he or she can answer your questions or direct you to someone who can answer them. Thanks, and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.